duties and functions of the protection officer. Very, very elaborate duties, very, very serious duties, which cannot be taken away as that, oh, one woman comes to me crying like this, I just better do her something, or pay her some money and keep quiet for 5 days. I'm on leave for 5 days, so just come after 6 days. No. He has got very, very serious duties to discharge, and he is responsible for the duties and the victim's violence also. So to assist the magistrate, make incident report, make a complaint to the, apply for protection order, ensure legal aid, see that he has to maintain a list of service providers, shelter homes, everything. But again we know that the support systems within the machinery for implementation has not been fully complied with at all, and we need to push the government to come with full-fledged support, financial-wise, personal-wise, infrastructure-wise. We will have to take a resolution within these 2 days so that we are representing the whole of the nation here in different states, and we are all going to push our state governments and the central government if necessary to see these mechanisms are full-fledged mechanisms. So the violence of women cannot wait for the budgetary allocation to come after 2 years or after 3 years. Just get an RTA application to your respective states and find out what is the budget allocation made for each state, each of the state, for the implementation of this law, for allocation of funds to these officers concerned or the infrastructure mechanisms in the state. So that's a duty cast upon us. I'm only reminding you before I forget it by the end of tomorrow. Okay, provide shelter to the victim, take her for medical aid, and all the needs which the victim is entitled to. We go to the next section. For any elaborate details, you can go to the rules in the Act, which says rules 8, 9 and 10. You must read it very, very cautiously to understand that the duties and functions of the protection officer. Next. Okay, this is one section where we make the application to the magistrate. We make it in the form. He has to fix a date for 3 days, then dispose the application, the entire application within 60 days, nowhere it happens. And anybody should tell me today and tomorrow whether any magistrate has passed any order, disposed of any application under section 12 within these 60 days. It can't be, it's not happening also.
Karnataka is.
Okay, thank you. In Karnataka it's happening, very good for Karnataka. Okay, file declaration. These are all the proceedings which happens in camera proceedings under counselor's facilities, shelter and protection orders. Go to the next section. This is a right to reside in a shared household. I told you earlier in the definition section itself, it's a very, very controversial, at the same time very, very useful, and we are here to examine how far this particular provision is being helpful for the victims. We have to decide, we have to discuss in detail within these 2 days to see how this section has been utilized, or how orders are passed and this residence orders are passed by the courts in this section. Next. And there is quite a lot of contradicting sections when we say that right to reside by a victim in a household can take away the fundamental right of the in-laws to own the property, dispose the property, and all those things as spoken to by Sheila and the bond. Next. These are all the orders. I am not taking you elaborately. You have been working on it. The orders which are available, and we have this protection order, which all acts can be protected from, stop violence orders which can be passed. We have the section 19 residence orders. Next. We have the section 19 residence orders. Then we have 20. The next section 20, the monetary relief, or what we can seek monetary relief of. We are all going to discuss these. I'm taking you urgently because of the time constraint, but we are going to discuss these sections in our orders within these 3 days, and the panel sitting here are also going to discuss with you about the implementation and the orders got on this section. So I'm not dealing with that elaborately. Okay, next one. Then the custody order and the 21 compensation order and the 22 and 23 are interim ex parte orders. Our High Court of Kerala has come up with a decision on 7th of January saying that interim orders you must be very, very careful to see that you give interim orders. So for order 39 rule 1 in CBC said, when made out, and when there is an arguable, debatable case, the party is entitled for injunction. It is a similar provision to stop injunction only, but then there was no necessity for a judgment to say the magistrate should be very, very careful in dispensing applications under 23 to ex parte orders, as if the sky is going to fall. I don't know. He's so much scared about it. Then he said pass an order first, pass another order after service of notice, then let the parties go on appeal, because courts are full of, the sessions courts are having lots of appeals, because they even appeal against the interim orders, ex parte interim orders. So with these orders, the other provisions which we are going to discuss in our time, in our discussions, with these provisions I stop here, and I will be adding on to the comments, and they will accommodate me in between to say the provisions of law which I have not discussed, and the laws and the judgments which have come, which I will be sharing with you in the coming sessions. Thank you for listening.
Thank you, Maria. I would now like to call upon Senior Advocate Vidya from Majlis, who will be talking on placing domestic violence with a broader framework of civil and criminal law.
Good morning, everyone. By way of introduction, I would like to mention I'm from Majlis, founder director of Majlis, and I'm very happy. I welcome all the lawyers and activists who are present here. It's been great to see so many of you responding to this call and coming here. आणि त्याच्यामध्ये महाराष्ट्रात आमचे काय वकील मंडळी आहेत आमच्या डिस्ट्रिक्ट लॉयर प्रोग्रामच्या अनुसार, तर सर्वांना आम्ही हार्दिक वेलकम म्हणून तुम्हाला सांगते. आणि आमचे पास्ट फेलोशिप आहेत आणि त्यांचे काम कसे झाले आहे, आम्हाला एक संधी आहे की आम्ही ते आता शेअर करू. As far as DV goes, but even your other experience, it gives an opportunity for us to interact with each other. And I thank HRLN for initiating this process of calling for a meeting like this and getting all the collaborators together on one platform. I think we need to make the best of these 2 days of interaction. It is also very heartening to see so many women lawyers together on one forum. For not least, it is a women-oriented program, and all our lawyers are women. But for HRLN, it is not a women-specific program. It is a general human rights program. Intimate that so many women lawyers are present here who are working on this issue, who are interested in the issue, and have come from different states. But I think that's a very positive response. Not that violence against women is a women's issue or women lawyers' concern, but at the ground level, if you see that, it's mainly women lawyers who are taking up this issue, or women activists. Between women activists and women lawyers, if you see, when you look at the cases, the importance of lawyers is evident. From everything that Maria said, it seems that the act will work somewhere else. It's not constrained to lawyering and lawyers. But in the last 3 years, what we see is the initiation of the lawyers that is taking the act forward. Of course, there are certain people as provided, designated as service providers. But the problem is, we know how technical magistrate court is, how legalistic the environment in the magistrate court is. Though the aspiration is that service providers will provide and protection officers will provide and so will provide and magistrate will respond. All of us know at the ground level to get one order from a magistrate protecting the woman's right to live, to stay, to reside has not been easy. Courts have not been all that helpful. And if you get an order in the magistrate, it goes on appeal in the sessions court, and if you get an order in the sessions court, it goes on appeal in the high court. So the legalistic mechanism is not done away with, though we would like to believe it is so. So the lawyers meeting, according to me, is most important, because lawyers in general and women lawyers in particular will be the one who will be defending this law for a long time to come, unless, of course, we have a very idealistic situation. State governments have budgetary allocations, protection officers are sensitized, they are there in the right place when the woman wants her, and there is no need for the lawyering community to enter. But that's not been the case. If we see from 2006 to 2010, what has happened is that we are called upon to make this act in favor of women, to make expectations. And another one to say at the ground level, take a woman's case, maybe go to the PO or go directly to the court, argue the matter, get the order implemented. I mean, all the steps that are there. Protection officers are supposed to help, service providers are supposed to help, but actually the women lawyers are playing a very crucial role. And by the response that we have got from here, this is evident that one is the lawyer community and secondly the women lawyer community. And hence this workshop becomes very useful for us. How do we take it forward? What are the difficulties we as lawyers face? And I think that is where we need to discuss for the next 2 days. In order to aid lawyers, we have brought this small booklet called Defending Women Against Domestic Violence. We prepared it specially for this meeting since lawyers are coming from very many different states. When we go to the courts to argue the case, many times magistrates, despite the media publicity, despite the so-called sensitization, the magistrates are not aware of this act. And when technical issues come up, all the time they say, show us a case law, show us what the higher courts have said, show us what the acts is and what the courts have said. And the courts are not speaking in one voice. Courts are speaking in different voices, in different states, at the Supreme Court, everywhere. So we have brought out this booklet as a ready referencer for your use and also for the use of the magistrate. Please share it with your magistrate whenever you are doing this case. If you want more copies, you can please write to us. Your copies here can be collected at a desk outside. Just give your names and collect your copies. We made it specially available for all the lawyers because I feel that lawyers will be benefited by this ready referencer book that we have produced. Of course, it is produced as of now as 2010 January, but I'm sure we can add up to it as more important cases come. And it is a compilation of only positive case law. It doesn't have negative case law. If anybody wants to use against women, they have to do their own research. We have not compiled it and got it in a ready-made form to say, okay, this is positive, this is negative, now you decide. Now we have one particular agenda to defend women's rights, and every material we produce must strengthen our cause. And if anybody wants to take produce something to counter the view, they must take the trouble to produce it and make it available for people who want to defeat women's rights. So this is very clear. So it is not comprehensive. It is very focused and serves our agenda. Now, placing domestic violence in the wider concern is the topic that I would like to address. Now, when we say domestic violence, and we look at the Act, and what the Act gives us or what the Act does not give us, we have several other concerns, some of which I will raise today and some of which I will raise